Hello, everyone. This is Tom Fox back for another episode of the award winning All Things Investigations. Today, I'm thrilled to be joined by Jeremy Payne and Diego Duran de la Vega. Gentlemen, first of all, welcome to the podcast.
Good evening. Thank you, Tom. Thanks for having us.
So, I wanted to start by asking you both a little bit about your professional background and your current practice. Jeremy, could I start with you?
Of course, Tom. My name is Jeremy Painter. I am a partner at Hughes Hubbard. My practice is focused on U.S. economic sanctions, which I have been focused on for almost 20 years now. I started my career at OFAC, which is the office within the U.S. Department of the Treasury that administers and enforces the sanctions that we're largely going to talk about today.
Diego.
So I'm a dually trained attorney. I'm licensed to practice in Mexico and in the U.S., specifically in New York and D.C. And before relocating my practice 11 years ago to the U.S., I used to be in another life a criminal defense attorney in Mexico. But since then, I've focused on representing clients from Spanish-speaking countries, mostly from Mexico, when they have a dispute in the U.S., including white-collar matters and investigations.
Gentlemen, I specifically asked if I could visit with you guys because of the February 20 cartel terrorism designation by the U.S. State Department. And maybe, Jeremy, given that you spent a good portion of your career there before coming over to HHR, could you describe what OFAC jurisdiction is and how that plays into this cartel terrorism designation?
Yeah, great. It's a great starting point, Tom. So when people talk about U.S. economic sanctions generally, what they're really referring to are two aspects of those sanctions. One is what's prohibited, and the second is what is sanctionable. So for that first question of what's prohibited, really you're asking who must comply with these rules. And predominantly you're talking about U.S. persons, which are companies formed under the laws of the United States, and individuals that are either citizens, lawful permanent residents, which is another way of saying green card holders, or anyone physically present in the United States. So that's the starting point, right? But there is a very broad extraterritorial reach for these rules. And some of the largest OFAC actions to date have been against companies for causing violations. So these were non-U.S. companies completely outside of the United States that engaged in certain transactions that then caused companies in the United States to violate U.S. sanctions. So the starting point is U.S. companies, but the actual application is very extraterritorial. In 2023, two of the largest civil monetary penalties that OFAC issued were against non-U.S. companies for causing U.S. companies to violate these rules. These were massive penalties, almost 500 million and 900 million US dollars, again, against non-US companies. So it's really the touch point to the United States is generally thought of as being US dollars, but it's not the dollars that trigger OFAC jurisdiction. It's really the use of the US financial system that is the most common way that OFAC can extend its rules outside of the United States.
Let's turn to the cartel terrorism designation. What was that designation and what does it mean legally? And then maybe how are you counseling clients or what questions are you getting now? And Diego, can I start with you on that?
Sure. And that's a compound question. So I'll dissect it, starting with some background, which is narco organizations, mainly in Mexico, have already been the object of blacklisting or designations by the U.S. government, specifically by OFAC. What is new here is that there's further designations for a different list, which is now a treatment of a terrorist organization. And clients are going to need to understand the severity of that distinction, because not only that by its own name is linked now to terrorist activity, but also is linked to what arguably is right now the number one object of the US government, which is national security tied to the total elimination of cartels, drug cartels. And we saw the executive order for President Trump. We saw the follow-up designation by the State Department. And it's very clear that the government has already picked the enemy, if you will, with these few entities that they designated organizations. There's no reason why we should think that it'll stop there, but it gives you a very clear idea of what we're dealing with. And these are, if you look at the maps, these are basically, these organizations are touching basically 5 or 6 countries in the region. But the only country that is basically all painted in a color, or 90% of it painted in a color, is Mexico. So this is clearly something really targeting Mexico. And so therefore the companies doing business in Mexico with operations in Mexico, and again, as Jeremy was saying, this is not only US companies, this is international companies from other places doing business or having operations in Mexico, but also Mexican companies. So, and I'm also going to add some background information as Mexico and the region. You get to understand that these companies, even though they're super sophisticated companies, the pure concept of U.S. economic sanctions could be very foreign and difficult to swallow. If you add to that the fact that these companies, most of these companies are purely in Mexico or in these other countries, and even though they have some points of contact and potentially some operations in the U.S., they see themselves as not a U.S. company. They see themselves as Mexican, Colombian, Venezuelan, Peruvian, Salvadorian companies. And so there's going to be a learning curve for all these companies to understand that this applies to them, that they need to take it seriously. And if they don't, there's going to be severe consequences because, again, now we're dealing with the possibility that the U.S. government, none other, is going to see them as supporting and financing a terrorist organization. I think there's a big loop from how these companies saw their potential inadvertent interactions with these organizations to what is happening now. And we can go into the whole extortion payments because I think that's something that is jumping out of the page immediately when this started to pop up, the designations. But I'll stop there in case Jeremy wants to add something. You want to direct the discussion somewhere else, Tom?
No, Jeremy, any thoughts on that intro?
Yeah, I mean, the important aspect from my perspective, the most important aspect that Diego just touched on is the fact that these rules, as I said, are primarily fall upon U.S. companies. So many domestic Mexican companies will be surprised to learn that their risk exposure is very different now, right? And they have dealt with the reality of the counter-narcotics sanctions program for a couple of generations now, right? And that hasn't affected their day-to-day business operations in many ways, but these new terrorism designations will. And in large part, it will not because of the foreign terrorist organizations that got all the press, right? But rather the accompanying specially designated global terrorist or SDGT actions that followed. That is because those SDGT designations trigger Treasury's ability to use what it calls the Terrorist Finance Tracking Program, right? And that is basically now a surveillance tool on Mexican payments. Any payment that uses the SWIFT system, which is the vast majority of worldwide payments, it's almost 90% of all payment instructions are sent through that system. Any payment to or from Mexico will be able to, Treasury will be able to review those payments, right? And so you're dealing with a strict liability regime, which means that knowledge is not relevant, right? Any payment to a cartel affiliate is both now something the government will see and will review and likely will follow up on. Frankly, a lot of companies that operate in Mexico are in for a shock once this comes to their realization.
Jeremy, I heard another set of companies, businesses, or even verticals in your remarks, and that was the financial system, banks, or anyone else that might deal with money, cash, equities. Are they now need to be aware of their responsibilities with this designation, or is that something else?
Yeah, so I'll touch on some of that, and then I think Diego can give the Mexican perspective with respect to the new exposure that banks have. These new designations require banks block a much broader set of transactions involving Mexico. And the important thing to know about that is OFAC will be responding to those blockings. So when a financial institution blocks a payment, right, it then within 10 days has to file a specific report with OFAC. Beginning about a year ago, OFAC is responding to every blocking with an investigation. And so a lot of companies who don't understand how these new US sanctions actually apply to them will first have their payments blocked and then get a knock on their door from OFAC demanding that they provide certain information regarding that blocked payment. So it affects everything, Tom. So yes, U.S. banks will have to be more active and vigilant, and we see indications of that happening already. And then because of that, Mexican banks will also need to really enhance their compliance efforts in that regard. And Diego, you want to touch upon that?
Yeah, no, and just to add to what Jeremy mentioned, I think you hit on the right spot, Tom. I think banks are right now the number one worried entity or type of industry worried about the whole situation, because they are the gatekeeper in a sense. They have an enhanced responsibility and obviously exposure and visibility with the U.S. government, and really severe consequences if they don't function as such. So we had previously seen in connection with Latin American companies some blockings when it would relate to sanction programs related to Cuba, related to Venezuela, Nicaragua, but those were pretty rare. What but we would see those, and they would come to us basically saying something happened with a transfer I made, and the bank basically told me that there's something called OFAC that it was preventing from it to go through. Number one, what is OFAC? And number two, how do I get my money back? I kid you not, Tom. And this shows what I was saying before. There's a lack, even though you're facing potentially very sophisticated companies, there's a lack of sophistication when it comes to U.S. economic sanctions. So back then we saw that. We're going to keep seeing that, but only times 10, because of all these designations and the broader mandate for banks to flag and block transactions, we're going to see more block transactions that are landing on our laps with companies saying, again, what is OFAC and how do I get my money back? And it's always been tricky. It'll continue to be tricky, but there's a way to do it. And the way we've done it is you need to conduct a commensurate investigation, internal investigation, to understand exactly why those funds were blocked. And then according to whatever results you get from that, you need to redesign basically the compliance system of such company, train people, and obviously interact with OFAC and explain to the best of the possibility of the specifics of the case why they should unblock the funds.
We had another designation called the Specially Designated Global Terrorist Designation, and I wanted to ask you all, is this redundant to a terrorism-related designation? Is it supplemental to, adjacent to, all of the above, none of the above? But what's the significance of this specific designation?
So it is not redundant in that it is that specially designated global terrorist designation that then triggers this intelligence program called the Terrorist Finance Tracking Program that enables Treasury analysts to actually review SWIFT payments. And so it's not redundant of either the foreign terrorist organization actions or the pre-existing counter-narcotics or transnational criminal organization designation actions. It's an important new aspect that changes the overall risk profile.
Anything to add, Diego?
Not specifically to that, but I think something we haven't really hashed out is the fact that before these designations, dealing with these entities, organized crime entities, would only carry as long as there weren't any criminal investigation. That it was mostly you were dealing with civil liability. Now dealing with these cartels is gonna not only enhance your exposure in connection with this civil liability that you would have, but also criminal liability. And that's something that the clients, not only in Mexico, but in fact, the clients need to understand. They not only need to deal with potential OFAC actions, which are not criminal. They need to deal with criminal actions now from the Department of Justice, but also an additional civil liability exposure when it comes to victims of activity from these criminal organizations, now labeled as terrorists. And they have a private cause of action, civil cause of action to go against those who financed the activity that caused the harm and suffering and victimized them or their family members. So those three areas of exposure we need to keep in mind.
Yeah. So Diego, if I could just add a little bit to that, there was his last point about civil liability for victims of terrorism. I think is really important point, Diego. I think companies that operate in Mexico should understand that not only that there is that exposure, but the exposure is very flexible, right? The Supreme Court recently ruled in a case involving Twitter that it's a balancing test to determine liability. So under the circumstance where a company may be forced to pay extortion payments, they would say, hey, we're dealing with a known cartel affiliate, and we know that we have to pay these relatively minor payments once a month, but we don't see that as exposing us to that specific civil liability. The Supreme Court just recently ruled that, in fact, it would, because the more knowledge that a company has that it's dealing with a terrorist organization, the less materiality. So in the case of payments, the less volume or the less value of those payments if it would have to prove up. So that's a really important consideration, Diego. I totally agree.
So in terms of, I come out of the energy industry, and OFAC is a well-known term, and many energy companies have put in direct OFAC compliance programs, certainly since the first Trump administration, perhaps even earlier. So an OFAC compliance program it's not a trade secret. It's a well-known program to respond to OFAC. What makes these designations different, or perhaps what makes a prior constituted OFAC compliance program not really sufficient for what you guys or what we all are facing now?
Jeremy, why don't you get started?
Sure. So in part, it's prioritization of both companies and OFAC, but really it's companies responding to OFAC's prioritization. So under Trump's first administration and the Biden administration under his term, OFAC imposed 65 civil monetary penalties. So cumulatively 130, right? And under both Biden and Trump, OFAC only issued a handful of penalties that were counter-narcotics related that would have focused on Mexico. So of the 130, less than 10 were involving, at least in part, counter-narcotics. So companies haven't focused on this risk because they haven't really been forced to. Companies aren't going to spend money on compliance unless there's a business reason to, because if they don't, it'll cost more than compliant, right? That's generally how compliance and the business side coexist. So these are different. As Diego said, counterterrorism generally and quote unquote cartel elimination, as Pam Bondi's memo is titled specifically, are, I would think, unequivocally the number one enforcement priorities of the U.S. government at this time. It's where enforcement assets are being drawn together. So companies must respond to that.
And I would just add, I fully agree with Jeremy. It's the enforcement aspect of it, but also companies operating in Mexico really didn't have to deal with a compliance program designed to combat the potential exposure with dealing with terrorists, right? Which just immediately you would react to it. It's not the same to deal with a criminal organization than deal with an organization that deals in terrorism or has been labeled as a terrorist organization. And that not only creates an immediate reaction to it, which at least to me, you can see immediately the difference, but also the way it's all designed now. So that it's very broad and it captures a lot of activity, be that, material support to a criminal organization designated as terrorism. What's material support? It's a lot. It could be paying them. It could be getting services from them. Not only the terrorist organization is in the loop, but also everything around it, agents, affiliates. So basically, as a company, your whole ecosystem now, you need to know exactly who you're dealing with in a way you haven't done it before. You're really going to need to dig deeper than you were used to understand who's behind the company, that's behind the company, that's behind the company that you're contracting. And so I think that's what's changing now.
Diego, I think, aptly described banks as the gatekeepers for these rules. And the banks are spending a tremendous amount of money drilling far deeper down to get true clarity into the actors and operators in Mexico. And then if companies don't somewhat match the banking system's ability to identify cartel affiliated companies, they're just going to be lost in the dust as expectations continue to rise. So really, I think it sounds cliche, but it's a totally different risk landscape now than before. It's not even remotely the same. The banking system, the government through the TFTP program will have a tremendous insight into the true nature of these payments. I mean, companies will be forced to respond, so they can either enhance build a program or enhance an existing program now, or rush to respond to the U.S. government's demands that they do so at a later time. So it's really a question of when, not if.
And I would add to that, Jeremy, I fully agree that even if these companies have commercial partners that are even more it's even more relevant for them because they're in the U.S. or something like that, they will need to. You will treble down the necessity and the relevance for the companies operating in Mexico to do it. You mentioned the banks. Just dealing with the banks are going to be more harsh in terms of what the requirements will be when you transact with them, when you open accounts. And so from every angle we look at it, it just screams that there needs to be a change in how companies are doing structuring their compliance programs and addressing these risks.
As we move towards the end of this podcast, could one of you all say a few words about OFAC's position regarding extortion payments and why that is a significant difference, perhaps some prior policies or prior administrations?
Sure, I can touch on that, Tom. The OFAC's position, it reflects the U.S. government's position as well, and that's a strict policy of not paying extortion payments. They strongly discourage extortion demands. That there's a rationale behind that policy decision, but quite frankly, it does not take into account the realities of operating in Mexico. So in the U.S. government's position generally, and OFAC specifically, is to constantly remind companies that U.S. economic sanctions are a strict liability regime, which means that a violation is a violation. If a company makes a payment to a cartel affiliate, even if it doesn't know that it's a cartel affiliate, hypothetically, that would be a violation of U.S. law, assuming there's that jurisdictional hook that we talked about at the onset. OFAC's position is that with any other sanctions-related issue, the way that you mitigate the risk with respect to extortion payments is by having a sanctions compliance program that's commensurate with your risk. In other words, if something happens, if a payment is made and the government asks about that payment, the government at minimum wants to see that that payor has a functioning compliance program. And Diego, you want to?
I have a much less sophisticated response than Jerry, but I think it's still valid. I think it's different now because, again, you're not dealing with a payment, an extortion payment to a drug cartel, a drug cartel. You're dealing with a payment you're doing to a terrorist organization. And if you pair that with the fact that going after terrorist organizations that sell drugs, like I'm only mentioning in your email, and Trump has made it clear, it seems like that the landscape is primed to change. What we've seen before, both from the Department of Justice and OFAC, and how they dealt with extortion payments, which seems that they were willing to get in the facts and be lenient if they needed to be, and understand the circumstances. We may be at a junction that may change because of the enforcement interest of the U.S., where there may be no option for companies paying these extortion payments than to either exit the country, which is unbelievable. That's a completely existential option, or having to immediately disclose to the government and face the consequences of it. But either way, it means the stopping of the payments to these terrorist organizations, which in itself is going to cause a lot of trouble. And then again, you should go back to the question, then I need to leave the country? Either way, you need to have to stop the payment. So it's a moment of uncertainty, not only for client. I don't think we can point to a single lawyer who has the response to this because it's too early. And potentially this whole policy change has the objective of creating exactly this confusion and this uncertainty. And so it's soon to tell how exactly the US government is going to enforce that aspect. It's going to react to companies disclosing that they've been paying or they're being asked to pay an extortion payment. We will need to see how these first enforcement activities from the US government, both OFAC and Department of Justice, will come down. But definitely for the clients, you don't want to be the first ones. You want to hopefully wait and see what happens with others and then decide what to do yourself.
Gentlemen, unfortunately, we are near the end of our time for this episode. But before we leave, I wanted to ask you both if listeners wanted more information on yourself or the topics we've touched on, what might be the best place or places for them to go? And Jeremy, we'll start with you.
I encourage all the listeners to go to our website. It's hugheshubbard.com.
And is your firm profile on that site?
Both of our firm profiles are certainly on that site. And again, I'm Jeremy Painter. And
thanks, Ren. Yeah, thanks for the time, Tom. And yes, website, LinkedIn, look us up. And we've been very active in putting together client alerts and much more to come yet.
Gentlemen, I think I can safely say we will visit again.
Oh,
thank you both.
Thank you, Tom. Thank you, Jeremy. Bye.
Bye, guys.